Now, today is 221st Friday group meeting. The topic is New Criminal Laws, Part 2. Speaker is Mr. Justice Retired Nagamuthu, Senior Advocate. Yesterday he delivered lecture on the same topic on Part 1. Sir, now you can initiate.
Friends, good afternoon to all of you. Yesterday, we were discussing about the registration of a case under section 154 of the old code and the corresponding provision under the new BNSS is section 173. We are discussing about that.
Come closely.
So fan. Okay. Now, I was referring to section 173, subsection 1 and 2 and 3. Today we have to start from subsection 4 onwards. In section 173, subsection 3 I will read first, from there we will proceed further. This is a new provision introduced. Corresponding provision was not available in the old code. What is added? Without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of police station may, with the prior permission from an officer not below the rank of the DSP, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry. For what purposes? To ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days or proceed with the investigation. Here we stopped our discussion yesterday. Am I audible now?
Yes, sir, now.
Okay. Now we have to go to the next provision, that is subsection 4. Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police. This is the repetition of the old code. There is nothing new about it. When any police officer refuses to receive the complaint, register a case as required under section 154 of the old code earlier, and now under section 173, the remedy or the obligation of the person concerned is to forward the complaint to the superintendent of police by post. Then what he will do? The superintendent of police, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by this Sanhita, and such officer shall have all the powers of an officer in charge of a police station in relation to that offence, failing which such person may make an application to the magistrate. This is the improvement made now in this particular context. Earlier the law was that when you make a complaint or the information to the police under section 154, in respect of a cognizable offence, if the police officer declines or refuses to register a case, the remedy for you was to forward a complaint to the superintendent of police, and he can direct any other police officer to investigate, or he himself can investigate. That is the early provision. Now, when the superintendent of police himself does not take any action on the complaint, on the information, what is the next course available for the complainant? He is dealt with in the very same section now. See, it reads like this: failing which such aggrieved person may make an application to the magistrate. So he has to make an application to the magistrate. He is not forwarding any complaint, he has to make an application to the magistrate. First, complaint to the police, no action is taken. Then forwarding the complaint to the superintendent of police, no action is taken. Then thirdly, thirdly, to make an application to the magistrate. What is that application? In what way we have to make an application? That is dealt with, you see, in section 175. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter so and so. Provided that, this is a new provision, provided that considering the nature and gravity of the offence, the superintendent of police may require the deputy superintendent of police to investigate the case. So now power has been given to the superintendent of police. He can transfer any case and by directing the deputy superintendent of police to investigate. Now, subsection 3 of section 175 is important. I have already told you that under section 173, when the police officer refuses to investigate or register a case, and when you make a complaint to the superintendent of police, that also has come in your favor, you have to make an application to the magistrate, right? That is dealt with in subsection 3 of section 175. What is that application? Any magistrate empowered under section 210. 210 is equivalent to section 190 of the old code. Power to take cognizance by a magistrate. 190, it is simply repeated in section 210. It says any magistrate empowered under section 210 may, after considering the application supported by an affidavit, please kindly see, 173 simply says that you have to make an application to the magistrate. How the application is to be filed, what are the things which are to be filed along with that, is dealt with in section 175. Any magistrate empowered under section 210 may, after considering the application, 1, supported by an affidavit made under subsection 4 of 173. 173.4 I already referred to you. And after making such inquiry as he thinks necessary, and submission made in this regard by the police officer, order such an investigation as above mentioned. This provision is equivalent to section 156 subsection 3 of the old code. What is the change made now? Under the old code, whenever you want to make an application, textually there was no requirement for for filing an affidavit in support of the same. In the Srivastava case, this honorable court held, since a lot of false complaints are filed, it is mandatory hereafter that the complaint should be accompanied by an affidavit. So now that has been made statutorily in this provision. It says that you have to file an affidavit in support of the allegations. Then one more change now is, for making a reference under section 146.3, it is a very, very important provision. For making any reference under 146.3 under the old code, there is no hearing at all of the police or the accused. When a complaint is made, the magistrate will consider the same. He will read that. If he finds that there is a cognizable offence made out requiring investigation, without any hearing, without any further inquiry, he will simply refer the same to the police for investigation. Though this Honorable Court has been repeatedly holding that a reference under section 156(3) should not be made in a mechanical fashion, in practice, many magistrates commit the same mistake by simply referring it to the police without properly examining. Now, therefore, there is a welcome change made in this provision. What do they say now? First thing, he has to, please kindly consider, he has to hold an inquiry as he thinks necessary. First thing, he has to hold an inquiry. Inquiry with whom? With the complainant. He has to make an inquiry. Number two, not only that, he has to allow the jurisdictional police officer to make his submissions. Because we have already said, first complaint is to be made to the police, no action is taken, then you come to the magistrate with a complaint now, upon which reference is made under 156(3) of the old code. Now it is under section 175 of the new code. So under this provision, complaint is forwarded. The major and marked difference between the old code and new code is there was no inquiry contemplated under the old code before making any reference to the police. Now an inquiry is contemplated. Number one change. This is a welcome change. To avoid any false complaint being just like that made and being forwarded. So therefore an inquiry is now contemplated, number one. Number two, another major change made is that the police officer concerned of that jurisdictional police station should be called upon to make a submission in this regard. So now the 156(3) reference, which is now made under section 175(3), cannot be made in a mechanical fashion. These three things are necessary. I want to repeat the same because very often we may have to make an application under this provision. Number one, application supported by affidavit and other documents. That should be considered by holding an inquiry by the magistrate. Then he has to issue notice to the jurisdictional police to whom complaint was made, to inquire him whether complaint was made to you. Yes, it was made. Why you did not inquire into that? Why you did not investigate into that or inquire, held any preliminary inquiry? He will ask him. The police officer will make his submissions now. Section mandates that he has to make a submission in this regard. He may now justify that no action need be taken because we held a preliminary inquiry, we found there is no offence committed and therefore there is no need for any investigation. So acting on that, acting on such statement, acting on such a submission, the magistrate may refuse to forward the complaint to the police now, as it was done earlier in a mechanical fashion. It cannot be done now. There are two checks now. This is an important provision you may kindly have in mind. Then one more improvement made in this provision is in respect of any information or complaint made against a public servant in discharge of his official duty. We kindly see subsection 4 of section 175 deals with the same. Just see. I will refer to that. There was no equivalent provision in the old code. And earlier also I said that there was no equivalent provision like giving opportunity to the police officer. Now subsection 4 reads like this. Any magistrate empowered under section 210, that is 190 of the old code, may, upon receiving a complaint against a public servant arising in the course of discharge of his official duties, order investigation. So this is like a private complaint. This is like a reference under section 146(3) of the old code, now under section 175. So reference, say I already dealt with any complaint or information made against any person which does not even include the public servant. Now a special provision is made in respect of public servant. What are the other safeguards contemplated? Subject to number 1, receiving a report containing facts and circumstances of the incident from the officer superior to him. Number 1. So you cannot, if a complaint is made, making a request to refer the same to the police for investigation, the magistrate cannot do it at the outset. What he has to do is, he has to call for a report from the immediate official superior of the accused mentioned in the complaint as to what has happened there. Then 2, after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. No, before forwarding any complaint under section 146 of the old code and now under section 174, 175 against a public servant, 2 additional safeguards have been made. Number 1 is to call for a report from the immediate official superior of the public servant. Number 2 is that the public servant should be afforded an opportunity. See, if he is not a public servant, as I already pointed out to you, what are the safeguards? 1, inquiry. 2, calling the policeman to make his submission. These are the 2 safeguards made in respect of others. So far as public servants are concerned, and if the act is in discharge of his official function, not in every case, public servant attacks a person outside, that is not covered. If the act is in discharge of his official duties, then he has been given 2 more additional safeguards. 1, to call for the report from the immediate superior, and 2, very important, is to afford opportunity to the accused. Therefore, before making any reference under 146(3), the police officer, the court has to issue notice to the accused, issue notice to the immediate official superior. Only after considering his assertions, only after considering the report submitted, then only he can decide whether to forward the same to the police for investigation or not. Now here, one thing has not been made very clear in the new code. Though they claim that they have, see, we have got, as I told you, we have got experience of more than 50 years. What are the difficulties which we have faced so far as 156(3) is concerned? Now, there is a judgment of this Honorable Court which says that whenever any private complaint is made to a special court under the Prevention of Corruption Act, making out offences under the Prevention of Corruption Act, making a request to the court to refer the same to the police for investigation, this court has taken the view you cannot do it unless there is a sanction order obtained from the appointing authority as required under section 19 of the Prevention of Corruption Act. Therefore, it became highly impossible for making any complaint, getting it referred under section 156(3). For example, I see here is a public servant, an officer who has amassed wealth. I got all documents. I got the sale deeds in his name. All were purchased very recently. I got his salary, income and other details also. I am so confident that he is guilty of offence under section 13(1)(e) of the unamended PC Act, that is disproportionate wealth. Now, I as a private individual cannot go and investigate. Reason being that as per section 17 of the Prevention of Corruption Act, investigation can be done only by an officer not below the rank of a DSP or by an officer not below the rank of Inspector of Police, provided he has been specially authorized by the Superintendent of Police. So investigation cannot be done by an individual. How can he hold the investigation and submit all the papers to the sanctioning authority, namely the appointing authority, and to get sanction? so as to file a private complaint asking for a reference under section 156(3). This judgment was doubted very recently, and the matter has been now referred to a larger bench. The reference is whether sanction is required under section 19 of the Act before referring a complaint under section 156(3) of the old code for investigation. Manju Surana, you give a citation? That is yes, criminal appeal number 457 of 2018, very recent judgment. Date of birth. Yes, I will read the reference. See the reference. This has not been now rectified. In the new code, they could have said that for making a reference under this section 175, no such sanction is required. They could have clarified that. Now we have to, though, because this has not been clarified statutorily in the new code, we have to wait for judgment, authoritative pronouncement by the Honorable Supreme Court in Manju Surana's case. We have to still wait. So this has not been clarified under section 175. Now therefore, to put it in a nutshell, a private complaint can be made under section 175, making a request for reference to the police for investigation. That provision has not been changed at all, since this honorable court held that it is to be supported by an affidavit. Statutorily now it has been made that you have to file an affidavit also, and also documents. Thirdly, earlier the law was not that the police officer concerned should be summoned, should be issued notice and asked him to make his submissions. These are all the changes made, but still this major flaw as to whether sanction under section 19 of the Act, of the PC Act is required. Similarly, whether sanction under section 197 of the old code is required, even for making a reference, it has not been clarified. So we have to wait for the judgment of this honorable court on this aspect. Now, regarding forensic experts, so now that case has been registered, investigation has commenced, right sir? So during the course of investigation, now they have added one provision, that is 176 subsection 3. There is no equivalent provision in the old code. What they do now is that in every state, forensic expert should be appointed. Please, I will read that. On receipt of every information relating to the commission of an offence, which is made punishable for 7 years or more, the officer in charge of a police station shall, from such date as may be notified within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect forensic evidence in the offence, and also cause videography of the process on mobile phone or any other electronic device, provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility is in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. Therefore, for 5 years, the state governments have been given liberty to keep silence. So, at the end of the 5 years period, they have to provide for forensic experts. Why this 5 years time is given is that in no state we have sufficient number of forensic experts. The section says that in every case where the offence is punishable for more than 7 years, as a matter of rule, it is mandatory that forensic experts should be asked to come and visit the place of occurrence, take videography of whatever he does. For every case, for example, in a district, there may be several cases registered on a particular day. Immediately after registration of the case, information should go to the forensic expert, and the forensic expert should come and visit the place. First, he has to see where is the body lying. Let us take the example of a murder case, where the body is lying, where the blood is, where are the fingerprints available, and where the weapons are lying, whether there are blood stains on that or not, what are the markings on the ground. All these things ought to be done now by a forensic expert. It is really a welcome trend. In many cases, what happens now is, because of the inadequate knowledge on the part of the investigating police officer, these important evidences are either omitted or obliterated. For example, I will tell you that suppose there is a CCTV camera available there. The policeman has got no forensic expertise as to how to collect that, how to preserve that, how to send the same to the court. In many cases, in our experience, we have seen that though the scientific evidence of CCTV footage is very much available, that is not preserved properly, that is not produced before the court properly, that is not proved properly by following the procedure established in law. As a result, what happens? The CCTV footage is simply rejected. If CCTV footage is rejected, what people will think of is, the CCTV footage shows the manner in which the offence was committed. Who are the people who come, how this is done, how he was attacked, everything is there in the CCTV footage. But the court is unable to use the CCTV footage, all because of inadequate forensic knowledge on the part of the police officer. We cannot blame the police officer also. He is not an expert in forensic science. Therefore, now it has been made mandatory that within 5 years, the state government, every state government should appoint sufficient number of forensic experts, and those experts should be called upon to visit the scene of occurrence or any other connected place immediately after the FIR is registered. This is really a welcome one. We have to wait for some time as to how the state governments are going to respond to this. If this is responded to properly by the state governments, to some extent we can be sure and be satisfied that these difficulties that we have been facing, we means our institution, the judiciary has been facing, will surely be at least minimized. Therefore, we have to wait for this one. Now, after this, then 158 of the old code, 159, there is no problem, there is no change. Therefore, I am skipping all those things. Now come to section 160 of the old code, police officers' power to require attendance of witnesses. So under section 160, police officer can issue summons to anybody including the accused. Correct? So any person who is summoned under section 160 is bound to appear before him and make a true statement. Is bound to make a true statement. That is what section 161 says. So in this 160, a proviso has been now added. What is the proviso? Earlier provision I will read. No male person under the age of 15 years or above the age of 65 years or a woman or a mentally or physically disabled person shall be required to attend at any place other than the place in which such person, male person or woman resides. So, if the person who is summoned is less than 15 years of age, or 15 years of age, or if he is more than 60 years of age, or infirm, etc., etc., he cannot be summoned to the police station at all. This was the old code. So what is the remedy for the policeman? He has to go to the place where he or she resides to interrogate him. This was the old law. Now, one more provision has been added to this provision. We say, provided further that if such person is willing to attend at the police station, such person may be permitted to do so. I don't think that this provision will be utilized by the police in the proper manner in which the Parliament has expected them to do. I am sure or I am doubtful that this provision will be abused by the police. The earlier provision said, don't summon them. The woman, don't summon her to court, to the police station. Go to the spot, examine her there. That was the law. Now it says that if she is willing, what they will do? They will get a statement from her. So when the summons is served, they will get, I will come to the police station on my own. They will get such an endorsement. Then they will take them to the police station. They will do everything as they want. So therefore this provision, in my perception, is capable of being abused by the police. Now, then regarding 161 of the old code, now the corresponding provision is section 180. No change has been made. Regarding 161 of the old code, examination of witnesses by the police, no change. So I do not want to elaborate that, therefore. Now regarding 162 statements, statement falling under section 161 recorded during investigation. What is the purpose of using the same? Section 162 says that no statement recorded under section 161 during the course of investigation shall be used for any purpose. It cannot be used for any purpose except for contradicting the maker of the statement, provided he is summoned as a prosecution witness in respect of that offence. That is the only purpose for which it could be used. There is a provision which says that, however, this will not affect section 32 of the Old Evidence Act and section 27 of the Evidence Act, which means if it is a statement made by an accused under section 161, you can use it for a limited purpose of section 27, that is for discovery of a fact of the Evidence Act. Similarly, if it is a dying declaration, it is substantive evidence, 162 is not a bar. This is the old code. Now in the new code also, they have simply repeated the same. They have not made any change at all. The law is, so far as the statements of witnesses during the course of investigation, there is no change at all. You may recall to your memory, yesterday I made one statement. Now, if the offence is punishable for more than 3 years and less than 7 years, a preliminary inquiry can be held after registration of the case. After registration of the case, what follows is investigation. Now for the first time, this provision has been made which says that a preliminary inquiry, what for? To decide whether to investigate the matter or not. or to continue the investigation or not. So if you if you distinguish between an investigation and inquiry, there is a distinction between a statement recorded during investigation and a statement recorded during inquiry. Section 162 of the old code and the corresponding new provision under section 181 prohibits any statement recorded during investigation only. Could it not be argued now that this preliminary inquiry is not investigation, and therefore the bar under section 162 of the old code, now in section 181, is not applicable, therefore I will use it in evidence? Could it be done? It cannot be. It cannot be. Because in Lalita Kumari itself it has been held that statement recorded, at the time when the statement is recorded, it may be that there was no case registered, but subsequently case registered based on those statements. Therefore, this statement also would fall within the ambit of section 161 and 162. Though strictly at the time when these statements were recorded, there was no investigation. But these statements shall be considered as statements recorded under section 161. Therefore, the bar and other limitations contained in section 162 CRPC shall be applicable. So therefore, as I told yesterday, though it is a preliminary inquiry after the registration of the case, and though it is a statement recorded during such an inquiry, still it falls within the mischief of section 181 of the new code and section 162 of the old code. Otherwise, there is no substantive change or any cosmetic change made in respect of these two important provisions. You know very well that in every criminal case, the statements recorded under section 161 of the old code plays a very, very vital role. The purpose, how the statement is to be recorded, there should not be any delay in recording the statement. There should not be any delay in forwarding the statement to the court. What are the limitations, etc. So these provisions are very, very vital in the criminal administration system. Now, they have not made any change at all. Therefore, we can follow those judgments which relate to section 161 or 162 of the Code of Criminal Procedure. Then, regarding the recording of confessions and statements under old code section 164, now new provision is 183. In this also, they have not made any change. The only one thing which I want to highlight is, when such a confession or statement under section 164 could be recorded, what stage? Old code as well as the new code. There is no change, that is why I am highlighting this. Such a statement under section 164, now under section 183, or confession of the accused under section 164, now under section 183, can be recorded only during investigation and or before the commencement of the inquiry or trial. Inquiry commences as soon as cognizance is taken. As per Binubai's case, this Nariman says, inquiry commences the moment cognizance is taken. The moment charges are framed, trial commences. So this section covers both inquiry and trial. Therefore, a confession of an accused under section 164 can be recorded only during the course of either inquiry or during the course of investigation, not beyond. After the trial has commenced or after the inquiry has commenced, no such statement can be recorded. That is a benchmark. There is no change made in this provision also. You may kindly consider this. Then, In respect of 164, so I am sorry that I said that no change has been made. There is slight change. There is one proviso added. It's not very substantive. Which says, provided that such a statement shall, as far as practicable, be recorded by a woman magistrate and in her absence by a male magistrate in the presence of a woman. In respect of any offence relating to a woman, like rape, outraging modesty, etc. Such statement of the victim shall be recorded only by a woman magistrate. If no woman magistrate is available in the whole district, then it can be recorded by a male magistrate. One more provision has been added which says, provided further that in cases relating to the offences punishable with imprisonment for 10 years or more, or with imprisonment for life or with death, the magistrate shall record the statement of witness brought before him by the police officer. Because section 164 of the old code says the magistrate may record. Now therefore they want to clarify it. The magistrate has got now no discretion. If the offence is punishable for more than 7 years, whenever any request is made by the police, the magistrate is bound to record the statement. See, practically what was happening in all courts throughout the country, to my knowledge, is that whenever any request is made, the magistrate will never refuse to record. To my knowledge, no magistrate has refused to record the statement. But because the language used is may, they want to make it further clear by saying that if the offence is punishable for more than 7 years, the magistrate shall record, which means magistrate has got no discretion at all to refuse to record. Practically, no magistrate was refusing even earlier. Anyhow, they have now made this change. Now, one more thing which is very important is this. This is I am referring to the very same the proviso, provided also that if the person making the statement is temporarily or permanently, mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator shall be recorded through video, audio, electronic means. No difficulty in this. Now, a statement recorded under class A, that is by using the services of an interpreter or educator, a statement recorded under class A of a person who is temporarily or permanently, mentally or physically disabled shall be considered a statement in lieu of chief examination. This is the most worrying area. So some statement is recorded under section 164 of the code from a witness. That witness is mentally not alright, or he is permanently disabled. Then the statement recorded from him under section 164 shall be in lieu of chief examination, which means that statement can be used as evidence in the present trial. This is not there is nothing new about it. You may come to section 33 of the Evidence Act. There is a marked difference now. Section 33, I will read. This has not been changed also now. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose in a subsequent judicial proceeding or in a later stage of the same judicial proceedings. The truth of the facts which it states when the witness is dead cannot be found or is incapable of giving evidence. So if evidence is recorded already, now here what is recorded under section 164 is evidence which can be used later on if he is incapable of giving evidence now at the time when he is summoned. But it goes with another condition as per section 33, provided that the proceeding was between the same parties or the representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross-examine, that the questions in issue were substantially the same in the first as in the second proceeding. Explanation. A criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. Therefore, according to section 33 of the Evidence Act, if the evidence has been recorded from a disabled person and now he has become completely disabled to give evidence, that can be read in evidence provided when the earlier statement was recorded, there was an opportunity for the accused to cross-examine him. If there was no such opportunity, then it won't fall under section 33. Now, take the case of 164. Though 164 is recorded in the manner in which evidence is recorded, there is no opportunity for the accused to cross-examine. Therefore, the statement recorded under section 164 would not fall under section 33 of the Evidence Act. Therefore, it cannot be read in evidence at all under section 33. In order to overcome this, now they have made this provision. That is, they say, a statement recorded under class A of a person who is temporarily or permanently mentally or physically disabled shall be considered a statement in lieu of chief examination chief as specified in section 142 of the Evidence Act. Of the IPC, such that the maker of the statement can be cross-examined on such a statement without need for recording the same at the time of trial. I do not understand. See, earlier you say that he is permanently or mentally or physically disabled to give evidence. Therefore, you say that we will read the 164 statement in evidence in lieu of chief examination. But now you want me to cross-examine. So the accused puts questions. Can he answer? Can he respond to that? Is it practically possible? There is one more thing also, as it is pointed out by Mr. Shreyas, that we have to refer to section 118 of the Evidence Act, the old provision. 118 says, all persons shall be competent to testify, competence as witness. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions by tender years, extreme old age, disease whether of body or mind, or any other cause of the same kind. So, if a person who is temporarily or permanently mentally or physically disabled is not a competent person at all to give evidence. As per section 118, he should be a competent witness so as to be examined in court. Now, he is not competent because of his mental disability. Still, this new provision says, no, the statement recorded earlier from him will be treated as chief examination. You cross-examine. I raise an objection that he is incompetent. Therefore, you can't examine him now. Chief examination, already you keep that. In cross-examination, he should understand my questions and he should be in a position to give rational answers to the questions. Suppose I ask him, what is your father's name? He says, yesterday I went to school. This is an irrational answer. An irrational answer, right? I ask him, do you like cinema? I ask him, do you like cinema? He answers, my uncle died yesterday. Is it a rational answer? There are two tests so far as 118 is concerned. One, he should be in a position to understand the questions, number one, qualified. Second, having understood the question, he should be in a position to give a rational answer. Then only he is competent to be examined, which is mandatory. This has been held so in several judgments of this court, more particularly in one judgment 1976. Who is a competent witness? When as per the Evidence Act, he is an incompetent witness. He is incompetent to be examined as a witness. How can you justify this provision which says that the statement can be, the maker of the statement can be cross-examined on such a statement without the need for recording the same at the time of trial? I do not understand this. So this provision also needs to be considered by the Honorable Supreme Court. This is highly unreasonable, impracticable, contrary to the specific provisions of the Evidence Act in respect of the competence of a witness. Both are procedural laws. Therefore, my view is that this provision needs to be tested. Then, let us go to the search by police officer. I skip all those things. Then we will come to this 167. This is power to remand. So now there is a controversy going on. And as a matter of fact, Honorable Justice M.M. Sundaresh bench has referred this issue to a larger bench. The issue was this. As per the old code, initially, when the accused is produced before a magistrate with a request to give detention order, that is, we call it as a remand, though it is not strictly a remand. Remand is under section 309 of the old code. It is not remand, but it is only authorization to detain. The police officer can detain an accused after arrest for a maximum period of 24 hours, and within which he has to be produced before the nearest magistrate if the investigation could not be completed, with a request to further authorize his detention. That magistrate may or may not be the magistrate having jurisdiction over the area where the offence has been committed. Therefore, the language used is nearest magistrate, whether he has or he has no jurisdiction over the case. Nearest magistrate. He will remand. I do not want to go elaborately into that because my purpose is very limited. So when an accused is so produced, he can be remanded. That is, authorized. His detention can be authorized either in police custody. The language used is to such custody as a magistrate deems fit. Any custody. It can be police custody, it can be judicial custody, it can be custody to an officer, it can be custody to a relative or anybody else. So custody. So this custody, that is what we call it as police custody, can be made only during the initial period of 15 days. This was what we have been following all along. In Anupam Kulkarni, this Honorable Court so categorically held that the custody to police can be given only during the initial period of 15 days, not beyond. This law we were following all through, that is 15 days only. Now in Sendil Balaji's case, a doubt has been raised whether this 15 days custody as a whole can be given only during the first period of 15 days or even beyond that. In other words, the total number of days of police custody shall be for 15 days. It can be now 2 days, tomorrow 3 days, after some days it may be another 10 days, like that, whether in fractions which can be given. This Honorable Court was holding that yes, it can be in fractions. Any number of times you can change, but it should be done within the initial period of 15 days. Therefore, during the initial period of 15 days, N number of times you can give police custody, but the total period shall not exceed 15 days. This was the law. Now in Sendil Balaji case, doubt was raised and the matter has been now referred to a larger bench. The question referred to is whether it should be only within the 15 days as a whole, no doubt about that. Whether it should be only during the initial period of 15 days or even after that. This was the question referred to. Reference is still pending. Now, what they have made in section 187, that is equivalent to section 167, they say that the 15 days period, 15 days custody can be given in fractions or at one stage, all within a period of 60 days or 90 days as the case may be. So you know very well that in respect of offences which are punishable for up to 10 years, the period of detention shall not exceed 60 days. After that he is entitled for statutory bail. In other cases it is 90 days. So within this period of 60 days, now it is said. Now we need not wait for the answer in Sendil Balaji's case because law has been now made. The total period will be 15 days, but this 15 days may be in fractions, but this should be completed within the 60 days or 90 days. So police custody can be asked now on the 30th day. Court may give for 2 days. Then on 35th day, the court may give for another 2 days. And on the 50th day, again they will ask for custody. So the court may give that time also. So in fractions it can be given up to 90 days or 60 days as the case may be. Now what is the problem for the accused in this matter? Practically speaking, when you move for bail in a particular case, that is after 15 days when you move for bail, the investigating officer may oppose, saying that no, don't release him on bail because we may require his custody. We may require his custody. The court may be inclined to refuse bail because his custodial interrogation is required. The police officer says that he may ask for, or why he may. The moment bail application is filed, he will file an application immediately. You are filing an application on the 50th day for bail. He will file an application immediately, saying that no, I want custody. Why? I want to confront him. There are some new material which I have collected. I want to confront. Please give. So on the 50th day, custody will be given for 10 days now. Very good. So 60 days over. On the 60th day, they will file charge sheet. So ultimately what will happen? You are thwarting the accused from getting bail. This will be unfair to the accused. Offending Article 21 is my humble view. I leave it to you to decide on this issue. Bail is the rule as held by Honorable Justice V.R. Krishna here. Bail is the rule. Jail is an exception. Though very recently one of the benches of this Honorable Court has casually said, not very seriously, that bail is the rule and jail is an exception, is not applicable to the PMLA, UAPA Act. UAPA. That is only casual reference or remark made. Let us not be very serious about it. But fundamentally, it is a recognized principle that bail is a rule and jail is an exception. Now, this rule is thrown into the wind by saying that for 60 days, don't release. I will be making application. The moment you file application, bail application on 20th day, they will file one application for custody, they will take him to custody. On 30th day when you make a bail application, they will make an application for custody. Like that, for 60 days the police officer can manage to see that a person is in custody, then on the 60th day he will file an incomplete charge sheet now. Incomplete charge sheet. When an incomplete charge sheet is laid, then he is not entitled for bail. Though Honorable Justice Krishnamurari bench held very recently that Sabaria case, he said that final report can be filed only on completion of investigation. There is no concept of filing incomplete charge sheet without completing the investigation. Therefore, this will not prevent the accused from exercising his right to come out on bail on the expiry of 60 days or 90 days as the case may be. This was the law laid down. It is a welcome law laid down by this Honorable Court. In the CRPC or in the new court, there is nothing indicated anywhere that without completing the investigation you can submit a report. So what section 173(2) says in the old code and the corresponding new code also is that on completion of the investigation, the investigating officer shall forward a report, police report, that is the final report. So on completion, so without completing the investigation, they indicate the investigation is still pending, this is only a preliminary report. But the courts, some courts were taking the view, though it is a preliminary report, it is a police report, therefore we are not, the accused is not entitled for the statutory bail under section 167(2). Now, therefore the judgment in Sabaria case was to the effect, no, there is no concept of incomplete charge sheet. You file complete charge sheet, until then he is entitled for statutory bail under section 167. But fortunately or unfortunately, that matter is now pending before a larger bench. Now, this Honorable Court, a larger bench, has directed that don't follow the judgment. Therefore, what is the position now? Because of the order, interim order passed by a larger bench, the position is that an incomplete charge sheet can be filed on the 60th day or on the 90th day, and bail can be prevented from being given to the accused. That is the position now. So as in the new code also, same thing continues. Now, one more thing. Now, what they have said is that whenever police custody is asked for, the accused should be physically made available before the court. He should be made physically present in court. But in custody, judicial custody is asked for, like extension of remand, etc., it can be done through video conferencing also. This is a fine. This serves a purpose, because when the accused comes to the court, when he is produced before the court, the magistrate will be in a better position to see his health condition, whether he has been manhandled in the police custody. All those things are there. And thereupon the views of the accused can also be heard. Therefore, this law is really a welcome provision, which says that whenever police custody is asked for, the accused must be made available, must be produced before the court, and only after hearing him, then the custody can be given to the police, or the court may refuse to give custody to the police. This is whereas if it is remand to any other custody, it can be done only to, not only, even by protection through video conferencing. One important provision which has been now added is a proviso to section 187, that is regarding remand. So you see the inconsistency in this provision. With this, I think that we can conclude today. So police custody can be given, or judicial custody can be. The magistrate passes an order giving police custody for 5 days, let us assume so, where he will be kept. Suppose the magistrate passes an order authorizing his detention in judicial custody, he will be kept in prison, no difficulty in that. When he is given to the police, where he will be kept? He is in the custody of the police. He is in the custody of the police station? No. He is in the custody of the investigating officer. He is not in the custody of the police station. There is a fine distinction between these two. Being in the custody of the police officer, investigating officer, and being in the custody of the police station, both are different. Now you see the proviso added. Provided further that no person shall be detained otherwise than in police station under police custody. If a person is given police custody, he shall be detained where? Only in the police station. Would it now literally, if you look at this provision, can the police officer take him to a different station, different place for the purpose of recovery? For example, the man is arrested in Chennai and the magistrate gives custody to the police officer in Chennai. Can he be taken to Kanyakumari and detained there for the purpose of recovery or not? What is this provision? Please see, look at it. It says that no person shall be detained otherwise than in police station under police custody. If he is in police custody, he shall be detained only in the police station. Which police station? Which police station, sir? The police station belonging to or traceable to the office. He has to be kept only in Chennai in that police station. He cannot be taken out. That is what it means, literally. So this section also should be brought to the attention of the Parliament to make necessary amendment. Then one more. Or in prison under judicial custody or a place declared as prison by the central government or the state government. You know that recently there was a judgment of Honorable Justice K.M. Joseph. That is Navaleka, Gautam Navaleka case. There a new concept was developed by this Honorable Court. It is neither police custody nor judicial custody, it is a house arrest. House arrest. Now, that judgment has been nullified by this proviso. Therefore, as per this proviso, there can be no, when police custody is given, he cannot be kept in house arrest. He can kept only in the police station. This judgment has been nullified in this. So this is all about the remand, the new change made in respect of the remand. Then we have to go to see all the other provisions related to investigation are the same, no difficulty. Now, in respect of the final report to be filed and the cognizance is to be taken, there are some changes made which we will cover tomorrow. Thank you so much.
Thank you so much, sir. How many people are really learned and benefited? Can you raise your hands? See, sir, how much I mean. Today is the strength also nearly crossed 70. Better than. We are grateful to sir, part 1 and part 2. Tomorrow, part 3 at 3 p.m., not 4 p.m. We'll start as usual Friday, 3 p.m. Let's see, sir promised that going to finish. If at all is not, we will take a call at evening and we'll continue. Thank you.